Good morning, Mr. Spear.
Good morning, Madam Chief Justice. May it please the Court, my name is Brownlow Spear, and I represent in this matter Mr. Carlos Fernandez. This is his appeal from conviction in the Middlesex Superior Court of possession of cocaine with intent to distribute, second offense, and committing the offense in a park zone. We raised three issues in our principal brief, and I want to argue them in the order in which they are presented in our principal brief. First is the motion to suppress the evidentiary fruits of a search of Mr. Fernandez's blue Honda automobile, which was parked in the common driveway of the three-family house in Watertown in which Mr. Fernandez, his girlfriend, and the girlfriend's son lived on the ground floor. The search of the Honda was made during the search by 12 police officers of Mr. Fernandez's apartment pursuant to a search warrant.
I have a fact question, please, Mr. Spear. Am I correct that no field test was done on the package in the car?
That's correct, Your Honor, yes.
Okay, and also that, and there was no test anywhere other than by the lab test of the weight on the cocaine, as far as weight?
That's correct, Your Honor, yes. The search warrant for the apartment was conducted by 12 police officers, and our contention is that the search warrant did not extend to Mr. Fernandez's Honda.
Mr. Spear, isn't this very much a fact question? I mean, has the judge so far messed up the law of curtilage that we should overturn a fact finding that this Honda was within the curtilage?
I respectfully think that the motion judge did not address the curtilage question correctly and in accordance with the case law.
He seemed to think that McCarthy was the governing case and that the facts here were very different from McCarthy.
Yes, and it's our contention that, in fact, the McCarthy case controls this situation. We read the McCarthy case as saying that an apartment in a multifamily dwelling, the curtilage does not extend outside the dwelling.
But McCarthy is so different. McCarthy is one of these great big buildings, condo or whatever, and the parking lot is far away and everybody parks in different spaces. This is totally different from McCarthy, it would seem.
Well, the facts are different, but we think the legal question is precisely the same. This is common property. It's not the exclusive use of Mr. Fernandez or the people in the ground floor apartment, although...
Was there any evidence of anybody living in the other units?
Yes, there was.
But there was no evidence of any other cars other than ones associated with Mr. Fernandez.
Well, there's no evidence that the police officers, while they had the place under surveillance, saw any vehicle other than those associated with...
They had it under surveillance
the ground
for a long
floor.
time.
But there's nothing in the evidence as to how often or how prolonged the surveillance was. And I think the motion judge's finding a fact that there was exclusive use by the ground floor apartment lacks any factual foundation whatever. So our position is that the law of the McCarthy case does control this situation. Yes, I realize that the facts are different, but we think that the legal principle stated in McCarthy does extend to this.
Isn't your best argument the one you finally get to in one of the last briefs, that regardless of everything else, you can't overcome the harmless beyond a reasonable doubt analysis applied to the lab certificates here?
Well, I think that's a very good argument, Your Honor. That, of course, comes somewhat belatedly.
Well,
but of course, I think it is a very good argument, but I respectfully think that we do have substantial merit with the arguments initially presented in the principal brief.
Because if you win on that argument, there'll be a retrial, and then you'll be back to square one with the motion to suppress.
right.
So this motion to suppress is not an irrelevant issue?
Oh, the motion to suppress is quite important, yes.
If I go to the field test issue, am I correct that the motion in limine was filed on the first day of trial?
It was filed before trial.
It appears to be filed on May 31st. Was that the first day of trial?
I don't know, Your Honor.
Well, I guess here's my concern. It's no more fair to the Commonwealth to ask for a Delbert Lanigan hearing with regard to this police officer than it would be fair to ask for a Daubert Lanigan hearing for a woman who took a pregnancy test. I mean, there's no way that this officer could have provided the information for Daubert Lanigan. So is it timely filed if the Commonwealth on the first day of trial seeks to challenge the legitimacy of a pregnancy test, which would clearly require substantial amount of effort by the Commonwealth to locate somebody who could speak to it?
I think the point is that either they could or could not pass the Daubert-Lanigan test. Now,
Well, but I mean, but they would need assuming they're entitled to it, they would need a witness who's going to speak to the virtues and the accuracy of this test. It's not going to be this police officer. He just basically touches it and sees whether it turns blue.
Well, I don't know who else could testify to it except that officer, Your Honor, Detective St. Ange, because he's the only person who, in the evidence, performed this field test on a plastic baggie on each of the
You would expect the
each of
Daubert
trash
Lanigan to be
bowls.
done by the officer who said, I take the piece in the instructions and I just dip it in if it turns blue, and that's I mean, it would have to be somebody from the manufacturer or some other expert who would speak about the scientific legitimacy that it turns blue only when there's a residue of cocaine. Wouldn't they?
I don't see how someone from the manufacturer or any other expert could testify to the legitimacy of these particular tests, and I think that
But you're
point...
going not to the
It's two
Daubert-Lanigan. You,
questions.
at that point, going to the whether this test was performed properly, which is a question for cross-examination. Or you're going to the qualifications of this, you're going to whether this officer performed this test in the right manner, and that's not a Daubert-Lanigan issue.
Well, the New Mexico decision that I have cited does include that within the
But
within the scope.
Daubert-Lanigan go to whether the test is generally accepted and whether it's reliable in the scientific community, whether it's considered reliable, not whether this guy did the test, follow 1, 2, 3 steps.
I think following the Sands case on which we relied below and also up here, I think the manner in which it is conducted by with the knowledge of the person conducting the test does enter into that, Your
No,
Honor.
but there are really two separate questions. One of them has to go with the underlying, whoever conducts it, is the science that makes, as Justice Gant says, makes it turn blue. Is that reliable science? That when it turns blue, that's a sign that cocaine is there? I thought you were raising both of them.
Well, I think a partial answer to that is that it's a little too simple to say that it turns blue. There are different shades of blue, and there are different things that will produce different
But
shades
I
of
thought you were
blue.
making both
and-
arguments. One, that it wasn't, we don't know whether it was good science. Two, in any event, even if it was, Detective St. Ange didn't do it right or wasn't competent to do it.
Well, I think it's that the pretty clear thrust of this motion is that he was not competent to do it. He said, quite frankly, when he was asked if he had any idea of how the test worked, he said no, he didn't. And I think there's a real question there as to whether this test is worth anything as far as being admissible in evidence under the using the Sands case as the precedent, which is also the fact of why we are putting such heavy emphasis on the New Mexico case, because it also looked to the New Mexico equivalent of the Sand decision as its precedent.
But we said in Canavan's case that Supreme Court's reasoning in Daubert held that a proponent of scientific opinion evidence may demonstrate the reliability or validity of the underlying scientific theory or process by some other means, that is, without establishing general acceptance. So what we're looking for in a Daubert-Lanigan hearing is the reliability or the validity of the underlying scientific theory, not whether this man performed the test properly. It's a separate question.
Well, I don't think I have a good response to that, Your Honor, other than to point to the New Mexico decision on which we urge the court to consider and, in fact, to adopt, because we think its reasoning is.
Well, I mean, there really are two issues. One is fair, and it's one issue, which is a fair issue, is should this field test be subject to Daubert-Lanigan? That's one issue. The second issue was, in the context of this case, was it fairly presented? If it was presented on the first morning of trial, before the Commonwealth would have any reasonable opportunity to obtain an expert who could speak to its scientific merit.
Well, assuming it was presented early on the first morning of trial, it was certainly argued extensively, and the trial judge considered it, and the trial judge reserved a decision on it, and it came up again repeatedly during the course of the trial until the occasion came for Detective St. Ange to testify to the result of the field test, and then the trial judge considered it further and issued a written opinion. I think this was thoroughly litigated, really with every opportunity for the different parties to have their say. And of course, the Commonwealth came up with this New York criminal court decision with the New York Corrections Department guidelines attached to it. And I think at that point I should go to my third issue, which is the motion to strike Detective St. Ange's testimony at its conclusion. Yes, Your Honor.
Can I just ask you one fact question before you shift arguments? Do you dispute the science that if you take a droplet of whatever chemical this particular officer inserted into the baggie, that if it is cocaine, it will turn blue? Do you dispute that?
I honestly don't know, Your Honor. I'm not. I have no scientific expertise. I've set out in a lengthy footnote which covers 2 pages 41 and 42, a number of the recognized questions that enter into this bit about the reliability and the validity of the field tests. And essentially I've pulled in everything that I could find on the subject, but I don't have any scientific understanding of it.
Before you go on to point 3, going back to your first point, could the police simply have walked up to this car in the driveway without a warrant?
I think they could have walked up to it, yes. I think they could walk up to it.
If they could have walked up to it, then they had probable cause based on the statement of the girlfriend or that there was cocaine in a hide inside.
Well, I wasn't conceding that they could enter it. I don't think they could enter it without a warrant in the place where it was parked. I think they could walk up to it and they could observe the external part of it.
Because the automobile exception would not apply, or because...
The automobile exception, our position is, and our position at the trial court was that it doesn't apply because the vehicle was not in a public place.
But in a place that the police could have walked up to and did a... Are you saying that because it's that when a car is in the driveway, you have to go get a warrant?
It depends on the driveway. If the driveway is attached to the house, a warrant for the house covers the car in the driveway.
Aren't you walking a rather thin line here about exactly what this driveway is?
It's a very close question. I think the Commonwealth has cited cases, the Simmons case and also a juvenile, in which there was an examination of the exterior of the car on private property, but neither of those cases involve a search of the car itself. I think it's an important. It may be a somewhat thin line, but I think the distinction is important, Your Honor.
And you rely on the fact that in the McCarthy case, McCarthy doesn't discuss Bacoyan at all. But I did have an opportunity to look at the briefs, and the briefs never mentioned Bacoyan in that case either. That isn't determinative.
It's not determinative, no. It does seem to me that Bacoyan, this issue just, it obviously wasn't considered at all.
Right, in McCarthy.
The question about striking Detective St. Ange's testimony, the New York Corrections Department document that the motion judge found very significant and appended to his written ruling speaks about that several tests should be conducted.
Excuse me, I want to go back to your Sands case 1 minute. That's
Surely,
the
Your
nystagmus
Honor.
case. That's the nystagmus case. Isn't the difference between that case and our case that Sands applies to a scientific correlation for which no scientific basis has been established? I mean, there's a question whether there's any scientific basis there. It's one of the possible junk sciences that Dobie and Lanigan are addressed to, whereas here we're talking about a scientific test that people have used that have been generally considered reliable by the community for decades.
I may have simply assumed that the HGN test is sufficiently in use to fall in the same category. That Your Honor may very well be correct on that point, but I thought we were talking in the HGN test about a recognized field sobriety test, and the question put up that under Dober-Lanigan, doesn't its scientific reliability have to be demonstrated? But but I take the point as a valid one. The striking of the testimony, the Detective St. Ange testified very unambiguously that he conducted a single swipe, and that doesn't accord with the recommendation. I'm sorry, my time is up. I have filed a motion for leave to raise the Melendez-Diaz issues. The Commonwealth's opposition is quite strong on the point that I have been very unduly lax in failing to recognize the presence of the issues, but I don't believe that it makes out any case for denying Mr. Fernandez of remedy from the constitutional violation. Thank you.
Thank you, Mr. Speaker. Mr. Bender?
Good morning. May it please the Court. Robert Bender, appearing for the Commonwealth.
Can I ask you, please, the same question that I addressed to Mr. Spear, but it really is the Commonwealth's problem, it seems to me. Just assuming that, I'm not expressing any opinion, but assuming you win on all the subsidiary points, and there are many in this case, but assuming you did, how do you get over the hurdle of the certificate not being harmless beyond a reasonable doubt, the certificate of analysis? You have nothing other on the cocaine that was found in the car, which I gather is the big issue in the case, and you have nothing on weight other than that.
Well, I don't think the Court is looking at the case the way the Commonwealth is. What was found in the automobile was a $40, I think a half a gram of cocaine. This charge was possession with intent to distribute and was based on
the trash pulls.
On the trash pulls, over 7 pulls, and what was found there. There was no evidence of the weight that was possessed at any particular time, this not being a trafficking case. And the Commonwealth not really able to proceed as if it were a trafficking case because it didn't ever find a weight sufficient to be constituting trafficking. As far as the certificates, there was a certificate for what was found in the car, that one corner bag, and there was a certificate for what was found in the trash pulls.
But given the fact that the validity of the test as performed was contested by the defendant, and the defendant did contest that this officer didn't do the steps that might have been required, so the validity of the test is an issue. And given the judge's instruction, the judge says something about this being a presumptive test, but laboratory test analysis make the final decision here. Those instructions, together with the fact that the field tests were contested, doesn't the lab certificate play a large part wouldn't it play a large part in the jury's thinking?
Are you speaking of the lab certificate as to the one baggie in the car, or the lab certificate, the separate lab certificate?
Either one.
The weight,
Well, either one. I mean, all right, stick to the lab test as to all the baggies, as to the trash pulls, also has the problem of the aggregation. But what I'm saying is, wouldn't that piece of paper have had an effect on the jury, given the dispute as to whether the field test was accurately performed?
Well, if I can break that down into a couple of points.
Sure.
First,
well, what you've got to tell me is why your evidence was so overwhelming that it doesn't matter what the certificate said.
well, first of all, the defendant doesn't raise a confrontation objection to the certificate in his briefs. And this is not a case that's subject to 33E review, so the Court cannot go out and look for an issue on which to
Unless
review
we
the
say
case.
it was futile for him to object
he
on this
raises it in the
basis.
reply
Even,
brief.
no, he doesn't raise it in his reply brief. He raises it in a letter to the Court 2 months ago. This case was submitted to the Court on its briefs at the beginning of the year. It was taken by this Court in December. At that time, the defendant had an opportunity and knowledge, as I point out in my opposition, to raise a Melendez-Diaz objection. He based his letter on DePina, which came down later, but already the Vasquez case, which was being handled by his own office, with an amicus brief written as to what was going on. That case was argued in January, but it was briefed by his office as an amicus in December before he submitted this brief. This isn't a question that he doesn't know that there's an opportunity or an issue out there. This is a question of whether the Court requires an appellant to follow the rules and actually put into a brief an issue that he expects to have the Court consider. And when someone doesn't put an issue into a brief. One is looking back to the case of Commonwealth versus Amaralt in 424 Mass, where it says that if you have an issue and don't brief it, you waived it. And if you waived it and you then present it to the court in a proper brief, the court has a different standard than if you had presented it properly. That standard is there a risk of a miscarriage of justice? And that is dependent on the issue actually being raised in a brief. Here it hasn't been raised at all. The defendant is asking for permission to raise it at this opportunity. And I would ask, out of all fairness, if the court feels that justice requires that its rules be modified in this application, so that Rule 11G2, I think it is, it said that he could have raised this in December when the court took the case. If the court wants to allow it at this point, the court should allow the matter to be fully briefed. The Commonwealth hasn't issued a brief addressing Melendez-Diaz and such, but I can say, as I said in my opposition, that the issue isn't even before the court. They're asking permission for it to be before the court. And to put the Commonwealth in a position of having to show, if it had been properly briefed, this is what we would have to answer without an opportunity to brief it, is really not a fair application of the rules to the Commonwealth.
Counsel, can I move back to the curtilage question for a moment? I have the question of whether the car that was searched, which was in the driveway of this three-family, is that a three-family? Yes. Was within the curtilage, as we've come to know it, of the house. I have your photos. I take it the car was down at the far end of the driveway.
Furthest from the street.
Okay. And there's a fence all around the yard, so it's within a fenced area.
Yes.
From the photos, is there a door down at the end of that driveway near where the car would be parked into the first floor apartment?
As far as I understand it, there is no side door on the driveway, but there is a back door from the backyard.
Well,
Was that in evidence that there was a back door from the backyard?
I believe it was at the motion that there was an evidence, because they were talking about whether, where trash was brought out to.
Well,
it was seen to be brought down the driveway to the street.
The point of my question was, it seems that the trial judge concluded that none of the other inhabitants on the other two floors would have any reason to go down to the end of the driveway because there was no way to get into the house from down there for their apartments. Is that correct or not?
I'm not really sure that that's correct. What I think is correct is that the judge said, and this is subject to a clearly erroneous review of his findings, that the only parties who used this driveway for parking at all were the defendant and his girlfriend, and their two vehicles were the only ones who were seen there over the 7 or 8 weeks of surveillance that was being done. There is a basis for that finding. As far as the judge had the photographs, as far as where the people come and go, it was presented that people come and go to this house up the separate walk up to the front door of the house. And
right.
this is really the access point that there wasn't any discussion. He indicated, excuse me.
Go ahead.
The judge indicated that it was difficult to make passage in that driveway when the cars were there because it was so narrow and it was fenced on both sides.
And I may be just
But
thinking
I
of
take
this.
it, Mr. Bender, that when you've got it seems to me from the photographs that there's enough space for 3 cars, that if you're in that kind of common driveway, it's not at all uncommon for the first person in to drive to the far end so that you can let the other 2 people in behind.
Well, I may share your opinion as to how many cars can be fit there, depending on the size, but the judge found that it had room for 2 cars.
Whatever it was, I was just going from the
Well, the
photograph.
judge found that it had room for 2 cars, and the 2 cars belonging to the occupants of the first floor were the ones that used it.
That doesn't undermine my point about why you would be at the far end of the driveway, which is if there are 2 cars and there's only one there, what you typically do is drive to the far end so you can let somebody in behind you.
Or you want to go into the back door. I mean, can you get to the back door from this driveway? The judge doesn't make a finding on that, and we can't tell from the photo.
I really only have what the photos show.
All right. And I may be
what the
thinking
judge
of
said.
another case in which it's a relevant factor as to whether the other inhabitants of the building would have to walk by the car to get in to get access. And I take it that's not here. There's a front door. That's where everybody goes in and out.
That's correct.
If there's a back door, well,
I'm speaking from looking at the photographs and just sort of from a general sense of these are very common buildings in the Boston area, and generally they have a rear access and not just a front door because the building codes require them to have 2 accesses. There isn't an
My point
access
is
onto
as
the
to-
driveway, though.
My point is as to why the car was at the, there's no finding as to why the car was parked in the furthest end, and it seemed to me that a perfectly...
Both cars were present at the time, Your Honor. I don't know that the judge has to make a finding that one spot was designated for this car and one
I'm
spot
not
was designated for
suggesting
the other.
that. I'm not suggesting that. I'm just saying regardless of whether there is or isn't a back door, it doesn't make any difference.
I don't understand what the court is saying. May I say this, though? The Commonwealth's point, first of all, with McCarthy was raised, and there was a question about Baconian, which was decided several years before. In Baconian, it was made pretty clear that there was independent basis to search that car. The search in Baconian wasn't on the basis of a warrant to search some other place.
Yeah, but why wasn't McCarthy decided on the basis that it didn't matter where the car was located once probable cause to believe drugs would be in the car? Because if your argument is right, it seems to me, once probable cause is established to believe drugs would be in the car, which I think there was in McCarthy, then if the automobile exception applies, why did the court go into this big analysis about whether it was in the curtilage or not?
Because I'm not so sure that there was a statement in McCarthy that there was independent probable cause to search that car.
So you think that that's the basis of
Well,
McCarthy?
that would certainly that would certainly be a reason that we'd have to look to see if the warrant for the apartment was sufficient to reach the curtilage, because that's the normal question that comes up when you have a warrant for the apartment and not independent probable cause. If there were independent probable cause, as there is in this case, and there's no dispute about it, then you come to a different basis, and you have to make a decision. You know, it's not really necessary that the car is in the curtilage anymore. You have a search warrant that's good if it is in the curtilage. If it's not in the curtilage, the defendant is saying, well, it's not necessarily in a public place.
So you have an independent argument, apart from the curtilage, that because there's probable cause from what the girlfriend said, and because the automobile exception applies, that a warrantless search here is okay.
Well, that's if
That's
the
correct.
curtilage isn't, it's the
I'm
alternative.
saying that's your alternative.
And it's the motion judge's alternative also.
Right, right.
That's the basis for it. The defendant would have it that it has to be in a public way and not in a place. And that's why I submit that there are places that the public has, there was the case of the commercial Eggleston case that I cite, where there was a commercial lot. It wasn't a public way and so forth. And there again,
That's the very recent case, is that right?
that's a very recent case from 453 Mass.
Yeah.
And that's one where the court was looking then to say, well, even if there isn't an exigent requirement in a public place, you shouldn't sit on your probable cause in order to search. And that's not an issue in this case of sitting on probable cause.
Do you think, with respect to, going back to the field testing, the authorities, or some of the authorities, the main ones that the trial judge relied on, seem to me to be, if I'm recalling correctly, pre-Daubert.
Older cases.
Yes, older cases. I'm just wondering whether you think in 2010, which is post-1993, that a different rule might apply in terms of whether, what needs to be shown with respect to the field tests.
Well, I know I have just 2 minutes here, and I'd ask for a moment to really answer this question. First of all, what the defendant was objecting to at trial, and has made an assertion that the field test that was being done by Detective St. Ange was going to be used in this trial as if it was a forensic lab test to conclusively identify. And that is not correct, and that wasn't asserted.
Say the testimony was because it was presumptive.
It was strictly a presumptive test, and the judge gave an instruction on language requested by the defendant and drawn from the New York cases that he criticizes, saying these are the things that the jury should know about it. And by making it extremely clear to the jury that this is a presumptive test, that it is subject to error, that a conclusive test by a forensic lab is necessary in order to give you a conclusive statement as to the identification, this took away any doubt. Now, the New Mexico case,
But
Morales...
yet then you run headlong into the Melendez-Diaz problem, and that you say you overcome it by improper, untimely filing of the argument.
Well, for one, in the Connolly case and in some appeals court cases, the court has specifically referenced field tests as one of the objective factors that can be used by a jury and can be used by the Commonwealth, even though a certificate has been introduced without any objection whatsoever, whether it's futile or not. And I submit in this case it was tactical, because the defendant didn't have the chemist present to say, how was this test run as far as aggregating from the 7 weeks of bags one substance? And without having the chemist there, the defendant can't get that testimony in, which is what he was using to attack the results of the lab test and attack the basis of the field test. Said that you didn't confirm each week that these field tests were actually something by having a lab run a test of each week's pull. They ran one test for the 7 weeks pull aggregated together. To get a basis for that in, he needs the chemist who actually did the test. He didn't have it. He stipulated with the Commonwealth, and at the same time then he is, in my opinion, waiving his objection that it would have been futile to make, that he has to confront that same chemist that he's not willing to call. He can't have it both ways. This is his stipulation. This is his tactic. This is why he's not raising this issue initially, even when the Commonwealth points it out to him that he hasn't raised it. Now, the court really hasn't recognized any exceptions, it appears, but raising an issue in a case seems to be a valid one, that if it's not raised, the court cannot act on it. Now,
Thank you, Mr. Bender. Your time is up. We'll take a short break.
all rise.